Hello. In this video, I want to talk a little bit about the Constitution, which is the focus of Chapter 2 in your book. So, as you have read in Chapter 2, the U.S. Constitution was drafted in the summer of 1787 in Philadelphia. There were a group of 55 delegates who went to Philadelphia. They were all white male property owners, very wealthy men. Some of them owned slaves. Many of them do it actually, but they went to Philadelphia for the stated purpose of revising the Articles of Confederation, which was America's first constitution. And the problem with the Articles was that it gave way too much power to the states, and there was no really well-organized central government for the nation. So the delegates did go to Philadelphia originally to revise the Articles of Confederation, but once they got there, they really never talked about the Articles of Confederation. Within a few weeks after they arrived in Philadelphia, the state of Virginia, and James Madison was one of the main delegates from Virginia. Virginia introduced a proposal that came to be called the Virginia Plan, sometimes also called the Large State Plan. And essentially, Virginia's proposal was that we would have essentially a new central government for the United States. It would essentially do away with the Articles of Confederation and create a brand new central government. The national or central government would have power over commerce and taxation and the military and the nation's money supplies, currency. It would have the ability to establish post offices. It would deal with major national issues, which it had very little power to do under the Articles. And they also proposed that we would have a bicameral Congress, which means two houses, with representation in both houses based on population. However, the small states didn't like that. They thought it was going to give too much power to a national government. It would take away from the rights of the people. And they were particularly upset about the idea that Congress would be based on population. So eventually there was a compromise, which is referred to as the Connecticut or Great Compromise, which resulted in essentially what we have in our Constitution, a bicameral Congress with the House based on population and a Senate with equal representation. Each state gets 2 senators in the U.S. Senate. That's the way it still is today. But the other thing about the Great Compromise is it largely adopted the rest of the Virginia plan. So the idea of having a much stronger central government is what they agreed to, so that the government that they created in the Constitution was much stronger than what we had under the Articles of Confederation. A couple features of the Constitution I want to mention. First of all, the constitutional framers created a system of enumerated powers, which are sometimes called delegated powers, which lists specific responsibilities that the national government has. The U.S. Constitution doesn't deal directly with the states. The states have their own constitutions. States have sovereignty, which means they have the authority to govern themselves. So the men who wrote the U.S. Constitution weren't focused on the states. They were focused on the powers of the national government. And so they did delegate to Congress, the lawmaking branch, the authority to coin money, to tax, to regulate interstate and foreign commerce, that is, trade with other countries, to declare war with other countries. That's actually a power of Congress, not of the president, and a number of other major responsibilities. The military is a big one. So the framers did create this system of what we call enumerated powers for Congress. They also have a section where they deny power to Congress, where they tell Congress there are some things you are not allowed to do. And then there's another section that denies power to the states. The idea there is that they were wanting to make sure that the states understood there are some things only Congress can do. One example would be the idea of coining money or establishing a military. That is a responsibility, or dealing with commerce with foreign countries. All of those are only responsibilities of Congress, not of the states. But then the understanding was that whatever was left over, whatever was not listed in the Constitution, would belong to the states. And eventually, when the Bill of Rights was adopted a few years later, the 10th Amendment, which is part of the Bill of Rights, said that whatever powers are not granted to the national government or denied to the states are reserved to the states. So we say states have reserved powers, which would include things like public safety and education and health and most of the things that we think of when we think of government are largely handled at the state level. That doesn't mean the federal government's not important. In fact, it's very important because it deals with national issues. But most of the laws we have to follow on a daily basis, maybe following the speed limit or when the idea that kids have to go to school, those are state responsibilities largely. But the national or federal government does deal with major national issues. So another thing I wanted to mention is that the framers of the Constitution also implemented a system of checks and balances. That means that there are three branches of government: legislative, executive, and judicial, and each branch has responsibility for certain things. For example, the legislative branch makes laws, the executive branch carries out the laws, the judicial branch interprets the laws, but a lot of that is overlapping. So a prime example is that while it's the responsibility of Congress to make the laws, it's the president has a major role in legislation because he or she can sign or veto bills that have been passed by Congress. And generally, the president has the final say on legislation. Now, there is a check and balance in the Constitution which says that if the president vetoes a bill, it goes back to Congress and they can try to override the veto. So if they are able to get 2/3 of the House and 2/3 of the Senate to vote to override the veto, then the veto is not sustained and the bill becomes law without the president's signature. So that's an example of a check and balance. Another example would be the ability of the Senate to either approve or not approve presidential appointments. So when the president appoints somebody to his or her cabinet, or when the president appoints somebody to be a federal judge, it's the role of the Senate to decide whether that person can serve or not by a majority vote. That's another check and balance. A third check and balance would be the fact that Congress declares war, not the president directly. Spending power: Congress has the power or authority to spend money. So if the president wants to, for example, during the Trump administration, there was an effort to build a wall with Mexico, and under the Constitution, only Congress can appropriate the money for something like that. The president is not supposed to do that on his or her own. Impeachment: another thing that came up during the Trump years was impeachment. The president was actually impeached twice. And impeachment is an indictment by the House of Representatives. It doesn't mean the president's going to be removed from office, but what happens is then a trial is held in the Senate to decide whether the president is guilty of the crime, and it takes a 2/3 majority of the Senate to remove a president from office or to deny him his rights, or not to deny his rights, but to deny him the right to serve in office. So that's an example of a check and balance. There have now been 4 presidential impeachments in our history, although none of the presidents actually had to leave office before their terms ended under that, because because of the way the system works. So hopefully that makes sense. Last thing is that the role of the courts in the checks and balances system: they decide whether laws are constitutional or not. So the U.S. Supreme Court can strike down a law if it believes that the law violates the Constitution. The U.S. Constitution does contain a supremacy clause, which means that the U.S. Constitution is the supreme law of our country, and any law passed by Congress is part of that. So that means states are obligated to follow federal laws, and it's the role of the Supreme Court to decide whether either a federal law or a state law goes against the U.S. Constitution. And if it does, then the court will strike that law down. Now, the court only acts when somebody brings a case to them. So when Congress is considering legislation, the Supreme Court does not give them advice on whether to pass it or not. It's up to Congress to pass the legislation. The president decides whether to sign it, and then if someone doesn't like a law that has already been signed, they can go to court and try to challenge it, and then the court will look at it and decide, yes, the law is fine, or no, it violates the Constitution. So those are some examples of checks and balances. There's a chart in your textbook about this. But checks and balances were put in place in the Constitution to ensure, or try to ensure, that the rights of the people would be protected. Again, there was a fear among many people that shifting so much power to the national government under their Constitution would allow it to take away people's rights. And so one way to correct for that would be to have a system of checks and balances where each branch can do things to counteract the other branches and hopefully limit the infringement of people's rights. That system has worked well at some times and not well at other times. And of course, the framers of the U.S. Constitution did not envision we would have a political party system. We now have two major political parties, the Democrats and Republicans. And of course, it's become harder when, for example, we had a Republican president for a Republican Congress to push back at that Republican president. Even though sometimes an argument can be made that that president, if we're talking about Donald Trump, did things that violated the Constitution, or at least were taking on too much power, and Congress, when it was led by his party, did not really push back on him. And then as we go into the Biden years, we'll see if a Democratic Congress would push back on a Democratic president. But again, the framers did not envision political parties, and that's a bit of a complicating factor in terms of checks and balances, because a lot of times people who are in a political party in Congress don't want to push back at a president of their same party. And then on the other end of things, if the other party's person is president, they're much more willing to push back. So, and the question is that healthy or not for American democracy? But so the Constitution we have contains a lot of features. There's more discussed in the book, including the amendment process. So make sure you've read that chapter very carefully. And if you have any questions, as always, please email me or let me know. Have a great week.